We have important Second Amendment news involving Hunter Biden, specifically Hunter Biden's motion to dismiss his indictment in the United States District Court for the District of Delaware, specifically arguing that 18 U.S.C. 922G, as applied to people who are in possession or use illegal substances such as illegal drugs, are not allowed to possess firearms. Hunter Biden filed a motion to dismiss his indictments on the grounds that this relevant federal statute is unconstitutional under the Second Amendment, and the judge has denied his motion to dismiss. Now, I'm not sure this was as well argued as it could have been. Let's talk about this when we get back and what might happen next in the Hunter Biden Second Amendment fight in the District of Delaware. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarm What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, Hunter Biden, the son of Joe Biden, the president, has been indicted, as you know, for possessing a firearm, acquiring a firearm in the state of Delaware, while at the time he was a user, allegedly, of illegal drugs, which, according to the indictment by the United States Department of Justice, David Weiss, the special prosecutor, this violated federal gun control law 18 U.S.C. 922G that says that you're not allowed to be a user of illegal drugs and possess firearms. Now, Hunter Biden's lawyers filed a motion to dismiss the indictment, arguing that this federal statute violated the Second Amendment. Here is the essence of the argument as articulated by Judge Noriega in the District of Delaware in denying the motion. Defendant Robert Hunter Biden is charged with possession of a firearm by a prohibited person in violation of 18 U.S.C. Section 922G3 and two false statement counts under Sections 922A6 and 924A1A. Presently before the court is defendant's motion to dismiss the indictment based on the Second Amendment. In particular, defendant argues that the indictment must be dismissed because Section 922G3 is unconstitutional under the Supreme Court's decision in Nysurpa v. Bruin. Defendant argues that the charges under Section 922A6 and 924A1A must be dismissed as well because his alleged false statements regarding drug use are only illegal if Section 922G3 is constitutional. For the reasons set forth below, defendant's motion is denied. So Hunter Biden lost this motion, but should he have done so? Well, let's break it down a little bit. I should make, and this is a very important distinction, Hunter Biden's lawyers argued that the statute was facially unconstitutional. I'm not sure I would have gone there by itself. And what a facial challenge to a statute is, it's very hard to win. What you're essentially saying is there is not a single conceivable case or a single conceivable individual in any situation on earth that could possibly violate the statute, and thus facially the entire statute is unconstitutional. So basically Hunter Biden's lawyers, at least as understood by the judge, was that there's no situation for any individual in the United States who could be denied the ability to possess a firearm because of illegal drug use. And Judge Noriega here basically said there's really no authority to strike down this entire statute on those grounds. And then she pointed out that she didn't think that Hunter Biden's lawyers or Hunter Biden had really argued an as-applied challenge specifically to him. And in light of that, she's like, look, I'm going to deny the motion on facial grounds, but I will do it without prejudice, which means after the trial, when the record is developed, if you want Hunter Biden and your Hunter Biden's lawyers, you can file a motion to dismiss the indictment or the case on the grounds that as applied to you specifically, as opposed to facially as applied to everyone on the universe in all situations, but as applied to you specifically, as applied, hear what I just said, as applied to you, Hunter Biden, you can argue that as applied to you, the statute's unconstitutional under the Second Amendment. If I were representing Hunter Biden, I might have really emphasized that more and said that, look, the only way that Hunter Biden could be indicted here is if he was found to be violently dangerous to himself or to somebody else. There's simply no allegation or suggestion that's the case here, and therefore there's no historical analog law that would justify putting him in prison and thus justifying that federal statute, that federal gun control statute as applied to him, because there's no suggestion Hunter Biden has ever been physically violent to himself or to others. That is at least maybe a better way to have argued this and framed this. Again, we'll see what happens if Hunter Biden gets off. It will all be good for him and his lawyers. But again, perhaps when they argue this again, maybe they'll be a little bit more focused on Hunter Biden's situation himself. Now, I think the judge here did a adequate job, good enough for government job in applying the Second Amendment, but the truth is, I don't think this reasoning will ultimately be the law of the Third Circuit Court of Appeals or the Supreme Court. I don't think it was that strong of a reasoned decision here. To begin with, Judge Noriega relies upon the dicta that the anti-gunners always like to use, and I'll read it to you because you'll remember it. Again, there was no real analysis here by the Supreme Court in Heller and McDonald of this language that I'm going to read to you. They just sort of said it to narrow the scope of those decisions, but they didn't really set forth the standard for future cases. This is what Judge Noriega quotes, and as this is particularly important in deciding this case against Hunter Biden. The judge in Delaware writes, quote, "Instead, the Second Amendment allows for a variety of firearm regulations, including the long-standing prohibitions on the possession of firearms by felons and the mentally ill." And then she quotes McDonald to say, "We made it clear in Heller that our holding did not cast doubt on such long-standing regulatory measures on prohibitions on the possession of firearms by felons and the mentally ill." Now, Judge Noriega here basically relies on that heavily, but again, all that is dicta in Heller and then McDonald saying, we're just saying that we don't have to get to these kinds of questions, so don't use this case in and of itself to knock out those laws. It really didn't say anything beyond that. Nevertheless, she used that as a significant reason why she ruled against Hunter Biden. Then it goes on where she says, well, there's a couple Court of Appeals cases that said that facially this relevant federal statute is constitutional. And all she really did is she kind of like relies on that precedent. Remember how I told you that brick by brick by brick, every little win for the Second Amendment can be used by other judges to rule in favor of the Second Amendment? This is an example of it working in reverse, where here's Judge Noriega looking at this. She doesn't really analyze the historical analog laws to justify this federal statute. Instead, all she does is she appeals to authority by saying, well, there's a couple Court of Appeals rulings that say the statute's facially okay, and there's a bunch of district court decisions, which are just lower trial courts, that say the statute's okay. No one's really saying it's not, so I'm just going to go with the crowd and just follow the herd mentality, which is not unusual for courts to do, which is why it's very important that we win every conceivable case that we can possibly win for other judges to try to rely on these other cases to justify knocking out gun control laws. But here's an example where she does the herd mentality, but of course the herd mentality so far is ruling that this particular federal statute's okay. I don't think ultimately it is. But then she goes on to say that in addition to relying on these district courts and these courts of appeals, she tries to draw an analogy, and this is where she goes off the rails, I think, a little bit in terms of her analysis. She tries to talk about how being a drug user, a illegal drug user, is sort of analogous to the mentally ill. She analyzes the fact that when you're mentally ill at the time of the founding, they would sometimes put you away. And then here's where she really goes off the rails. She talks about the late 19th century, which is way, way too late to tell us anything in terms of undercutting Second Amendment rights, because as you know, the Second Amendment was adopted and ratified, went into effect in the year of our Lord 1791. So to use laws and events from the late 19th century, over 100, like almost 100 years after the Second Amendment was ratified, is really too late to tell us anything what the people that created the Second Amendment understood it to mean in 1791. So she's talking about the late 19th century, the late the late 1800s about how mentally ill people were treated. But again, this begs the question, as I see it, and what I might have done, or if I were representing Hunter Biden, is to really have laser focused on to say, look, the only reason why the mentally ill people were put away was because they were viewed to be violently dangerous to themselves or to others. And here, there's no suggestion, I would argue, that Hunter Biden has proved to be dangerous, violently dangerous to himself or to others. As far as I know on this record or anything I'm aware of, he's never threatened to kill himself. He's never taken steps to kill himself. He's never taken steps to kill anybody else. There's no evidence of physically violent behavior on his part toward himself or to others. And I would say, yes, maybe you might put mentally ill people away when they were a violent danger to themselves or to others, but that is simply not present in any respect when it comes to Hunter Biden. And therefore, the law as applied to him simply cannot stand constitutionally under the Second Amendment. I think that might have been a slightly more persuasive argument than what at least Judge Noriega seems to be making out that Hunter Biden's lawyers argued. But again, it may not matter because she's left open the door for the lawyers to come back and make all sorts of Second Amendment arguments, later on in the case. So not all is lost from Hunter Biden's point of view or from the point of view of the Second Amendment. Now, the other thing I want to mention is these other statutes were false statements, allegations that Hunter Biden made false statements on his 4473 because he was asked, are you addicted to drugs? Do you use these illegal substances? The typical questions on the 4473. And guess what? He says, no, no, no. And now they're saying, well, that was a lie. So now in addition to the fact that you actually possessed a firearm illegally while you were using illegal substances, that's a crime in and of itself. Beyond that, you also lied on the 4473. And now, of course, Hunter Biden's argument, which I think is not a bad one, is to say, look, the only way I can be convicted of lying on the 4473 form is if those lies were material. And the only way my lying about my use of illegal substances or illegal drugs would be material to the question is if the federal statute that says I'm not allowed to possess firearms if I'm on an illegal drugs or I use illegal drugs or whatnot, only if that's constitutional can the statements about my use be considered material. And if they're not material, I cannot be convicted as a matter of law. And I do think those are pretty strong arguments. But again, this is all going to depend upon whether or not Hunter Biden can knock out that federal gun control law as applied to him, which I think he's got a real shot at after the trial. But before the trial, at this point, I think he's not going to be able to pull that off. So the next step is likely if he's either going to cut some sort of a plea deal with the Department of Justice, or if he can't, then the case is going to have to be tried. And then we'll see what a jury in the District of Delaware says. I don't know, but that's where we will stand, and that's what will happen next. So anyway, I will put a link to this decision of the United States versus Hunter Biden down below. You can take a look at it. I don't think it's a particularly well-reasoned decision by this judge. I would give her maybe a C+, B-, good enough for government work kind of grade for this. I frankly would have expected a stronger, more thoughtful opinion out of this judge. She's done pretty well in the past, and I think this was just a passable effort on her part. I would have liked to seen a stronger opinion out of this court because she's done pretty well in the past. I don't think this was Judge Noriega's best work, but nevertheless, we'll see where it goes. Keep in mind that Judge Noriega, you may not remember this, but she's the one that is the first judge in American history to find that you have a fundamental Second Amendment right to make your own gun. So it's not like Judge Noriega is bad on the Second Amendment or bad on guns or anything in that respect. But again, on this decision, I thought her opinion was not as crisp and not as good as it could have been and not as analytical as I would have liked to have seen. But again, she's not my law student, so I'm not going to grade her. She's a federal judge. She's going to make her own decisions, and if she gets it wrong, then the Third Circuit and maybe even the U.S. Supreme Court will have a crack at what she has to say, but only time will tell. All right, folks, make sure you follow me on X at 4Boxes Diner. Hope you enjoyed today's show. Please follow me and subscribe to this channel. We're trying to get to 150,000 subscribers, and we will see you again soon here at the 4Boxes Diner.
Orders up. Table 2A.